It is April 7th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today we have an absolutely wild compilation for you. We've got Judge Simmons dealing with a defendant who thinks it's a perfectly fine thing to munch on a bagel during sentencing. Then we have Judge Johnson delivering an epic life lecture over a 10-year-old unpaid fine. And Judge Bryant is handling a heated Zoom contempt hearing where the defendant claims she was cursing at her phone, not at the judge. You know that goes over well. We've also got tense moments with Judge Middleton and Judge Aquilina today. So buckle up, ladies and gentlemen, because disrespect and judicial clapbacks are at an all-time high, and it all starts right now.
What are we going to do with Miss Hodson?
Judge, she's prepared to make an admission.
All right.
Elizabeth. It is going to be via no contest, Judge. If I could propose the bond information report as a basis.
All right, thank you.
Yeah.
House cleaning around here. Between now and Thursday, I have to move every single thing out of here too. You're getting out of here just in time as we dismantle everything. This is file number 26529FY. You're Elizabeth Hodson.
I hear Childers. I don't know why they have them on my last.
Well, I'd known you as Hodson, but Childers.
Yeah.
The allegation is that on March 21st, that was the same night those boys were out crawling around with a paintball gun at 4 o'clock in the morning in Sturgis. You were alleged to have assaulted or opposed, endangered, or resisted Seth Chittister and Gavin Flynn through his police department. What is the plea offer?
The offer is for the defendant to enter a plea to attempt R&O. We have no objection to a no contest plea. She was very intoxicated. The report indicates she was at a 0.317. So I think that's a.
Elizabeth, you're on probation for that earlier drunk driving charge. I think.
I don't think I am, no.
Maybe you just owe money.
I
You owe
believe
$595.
Right.
Are you on a payment plan?
I am.
All right. That was not good. It was close to your house. That whole everything where that earlier arrest went down all got destroyed by a tornado.
Mm-hmm.
But this ain't good. A 317 is scary territory. By pleading no contest to this charge, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. Do you understand?
Mm-hmm.
You have to say yes or no.
Yes.
All right. Oh boy. Attempted resisting obstructing the police officer is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that by pleading no contest to this charge, you'll be giving up your right to have a trial, and there won't be a trial? Do you understand that?
Yes.
If you had a trial, Mr. Nostriker could be there to represent you. All right, this is scary. You weren't far from home, but somehow you ended up down on Hoffman Street, passed out in a ditch. And the police picked you up. Someone reported that you were there and you fell and hit your head, and they took you to the hospital. And then you were combative with the officers at the hospital. Elizabeth became combative, swinging her arms and kicking at the nurse. The hospital staff hates these kinds of cases. Officer Flynn and myself. As Flynn walked away after her jewelry was taken off, she kicked him with both feet, barely missing him. Then she tried to blow snot and spit on the nurse. All right, we got to figure out what to do with this. Let's set this for sentence. Luke's going to be here on May 18th. We'll set it for the same day at 11 o'clock. What are you doing? Have you got back into treatment or rehab or anything?
No. I haven't had rehab or treatment or anything like that.
I want to look at that drinking driving case. I thought I put you on probation.
Honestly, I wasn't driving in that case, and as far as this case as well, I was not driving in this one either.
Well, you're not charged with drunk driving here.
Oh, I know, but I'm just
I
saying.
mean, it's close. Lucky it freeze to death. March 21st wasn't terrible, but you got it real bad, and you don't seem to be aware of it.
Can I just mention something about that night as well?
Yes.
I have been put on some hefty antidepressant pills that I had just started 2 weeks ago. And I really feel like that was a huge factor in that night for it to be that high. Because
Stop. You're lucky to kill yourself. Your antidepressant pills had zero to do with your blood alcohol level. It may have had to do something with your level of comprehension and intoxication, but prescription medication doesn't affect your blood alcohol level. You drank a large quantity of alcohol, which made you quite drunk. You're mixing it with psychotropic medication, and that is scary stuff. But it didn't raise your blood alcohol level. Those tests were 0.194. I did not put you on probation. Put you on a payment plan. I only charge you $595, and you still owe $595. You haven't paid 1 cent. What happened there?
I am having issues getting employment right now. My daughter had an episode earlier on in the year that I've been trying to deal with. She had a suicidal episode, so I've just been kind of home with her right now. But I am trying to look for employment.
We're going to have a long discussion on May 18th. Do you think that your daughter's mental health issues might be connected to your severe alcoholism?
No.
We're going to talk about that. I felt like I gave you a substantial break in that case. I made the fine quite low. I'm very disappointed to see you haven't paid 1 penny on it. You have very little insight into your level of your substance abuse issues. Bring your toothbrush. If you have this attitude when I see you on May 18th, you're going to get out about Labor Day. So I want you to try to gain a little insight. I also want you to pay something on that earlier fine. I can wipe it out with a jail sentence, but you're gonna hurt yourself. You're gonna kill yourself. Mr. Childers is there quietly acknowledging what I'm doing here. Your family all can see this. You seem like a nice person, but you need some intervention. I'm going to give you a breath test or a blood test that morning. See what your blood alcohol is at that time. Plus your conduct was terrible. You're kicking at the officers, you're blowing snot on the nurses. It's just bad. I don't want you to get in any more trouble, and I want you to start to pay on that other fine before I see you on May 18th. You're good to go.
This is docket 2395FH, People of the State of Michigan versus Aman Rashad Ross. Counsel, you are prepared for the record.
Good afternoon, Your Honor. AP Bart Buxton on behalf of the people of the state of Michigan.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Ross, who is standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under oath of perjury? Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had some time to speak to Mr. Goodrich?
Yes, I have.
Have you reviewed the status investigation report?
Yes, I have.
Thank you. On behalf of the phone, we can do this. Sir, you pled guilty to count 2, largely from the person punishable by 10 years. You recall that?
Yes,
On behalf of the people, what is your recommendation? And is there any corrections, additions, deletions?
There are some corrections, Your Honor. The main one being sentencing date. The sentencing date states March 20th of 2024. Obviously, it is now April 7th of 2026.
Any corrections? And then is there any additional jail credit days?
There are not, Your Honor. You would not be entitled to those.
Okay, thank you. So, under evaluation plan, changing the date and the first paragraph. And basic information. And then it's defense 26 of 26. Looks like I got all the places, but you never know. Is that it?
I think so, Your Honor.
All right, is there anything else?
And I guess I'm not sure how we want to handle this, but the update states that Mr. Ross is currently in MDOC due to a guilty plea of breaking and entering a building with intent on 9/30 of 24. That is not in the PSI. That happened after the PSI was created. I'm not sure if we want to add that in, or if we are fine with just keeping it in as it's in the update, it's still technically in the report. I guess I would leave that in the court's discussion.
Would you like to weigh in, Mr. Goodrich?
Your Honor, I think it being in the update is sufficient. I don't think we'd have to have it.
So this happened after, the offense happened after this.
Correct.
So let's just leave it like it is, because this would be reflected in that PSI.
Understood.
So good to know, but already probably taken care of. So, all right. Mr. Goodrich, any corrections, additions, deletions?
We do not have any, Your Honor.
As to the guidelines, any corrections?
I have 2 briefly, Your Honor. TRV 7 is currently scored at 0, but because of this new case of breaking and entering a building with intent, that is an incident that he was convicted of after the offense. So PRV 7 should be scored at 10 points.
No objection to that, Your Honor.
Thank you. And then the total PRVs would be 140. Does that change the level?
It does not, Your Honor.
And what was the OVs?
And then in regards to OVs, Your Honor, OV4 is currently scored at 0. OV4 is a psychological injury to the victim. However, I believe it should be scored at 10 for serious psychological injury requiring professional treatment. If you actually read the report, Your Honor, in regards to the victim's statement, let me get that exact quote for you. The victim has stated at the bottom of page 3 of the victim impact statement, this incident has caused her anxiety, and she is still struggling due to her sense of safety being gone. I would say, Your Honor, that based off of that statement, that would be enough for OV4 to be scored at 10, as she has suffered psychological injury with this anxiety that she now has dealt with since this incident.
Your Honor, we would object to the scoring of OV4. OV4 requires the required, she essentially needs professional treatment. She has not sought that. She's not made any reference to that. And honestly, her statement's 2 years old at this point. So there's no evidence that she ever did need that, Your Honor. So we would ask that remain at 0.
Is that, I have to look it up, but is that one that requires treatment? Because there's one that does not require treatment.
And Your Honor, my understanding is that it may require treatment, but the fact that treatment has not been sought is not conclusive.
All right.
Under MCL 777.34 subsection 2.
Mr. Goodrich, you've made your record. It's very clear she's suffered anxiety. I don't know if she's sought treatment, but it says may. So OE4 is 10. Any additional corrections?
No, Your Honor.
Mr. Goodrich, do you have any?
We do not, Your Honor.
So the total OEs is 20. Does that change the level?
I don't believe so. Let me double check, Your Honor. It does not.
Okay. I've also made a correction in the basic information sheet. Is the victim here? Does she just address it?
She is not here, Your Honor.
On behalf of the people, what is your recommendation?
Yes, Your Honor. There was a Killebrew agreement to no more than 12 months of upfront jail time at the time of sentencing. I will say that since then, obviously, Mr. Ross has picked up and pled to this case in Kent County. It's a breaking and entering a building with intent on September 30th of 2024. Obviously, Your Honor, because of that does potentially violate the court's orders is due to a new incident, and that Your Honor does not need to follow the Killebrew agreement, and the defendant would not be able to withdraw his plea at this time. With the guidelines being 19 to 38, I do believe that following the minimum range of 19 months would be appropriate in this matter, Your Honor, given Mr. Ross's situation afterwards, being that he did a breaking and entering a building with intent, and with this incident involving larceny, Your Honor, it shows that he's got this history, and he's got a pretty significant criminal history as well, Your Honor, which is what led to his PRVs being 140. So I would ask that there be a sentence to the 19 months, Your Honor. Thank you.
Mr. Goodrich?
Thank you, Your Honor. Your Honor, I believe at the time that the plea was worked out in this case, the thought would be essentially that he do some type of term of probation with the court. He had already served a full year in the county jail prior to being released by this court. Since that time, as stated, he spent 2 years now in prison. So he's done far more time than was ever contemplated for this case. And when you consider that since this incident occurred, he has been incarcerated for 3 years, essentially far in excess of the minimum guidelines being asked for. He did meet with the parole board this morning. They have not decided what they're going to do with him. His earliest possible release from the NDOC would be August. I would ask the court to sentence him to time served of 363 days on this file. He is with the understanding that he is going to serve at least another 4 months in the MDOC, and then he's going to be placed on parole, where he's going to be monitored. He's also planning to be paroled to Grand Rapids. So he's not going to be in this area. He's not going to come into contact with the woman who is the victim in this matter. And then if he steps out of line while on parole, he will be sent back to prison on this case out of Kent County. So we would ask the court to sentence him to a term of 363 days with credit for 363 days. I also just want to inform the court that while he's been incarcerated, he's been busy, improving himself. He's taking a builder's trade course. He's completed violence intervention prevention. He's been working on an advanced substance abuse class that he's nearing completion of. So he's treating all the issues that he's had that led to this incident years ago. So based on the fact of the age of this matter, we would ask the court to, like I said, sentence him to time served and essentially allow the MDOC to handle him from here.
Sir, what would you like me to know?
I think everything both parties said was correct, but like my attorney said, I have been dealing with the issues that I've been struggling with that led me to commit the offense that I committed that has me here now and after that. And I think I just finally realized that I had the ability to say no to drugs. At first, I never really recognized that I had that ability, so I think me being, I'm scared, Your Honor, to relapse. So I've never been scared before. And I think that's showing myself that I'm starting to actually take consideration of my actions. So I would appreciate you if you did honor the Killaboo Cat and sentence me to time served and let Kent County deal with me on parole.
So you're 41 years old.
43.
43. Oh, let me change that on here. Okay. Okay. Change it to 43. Half your life is over.
Right.
How much time are you going to spend behind bars in a jumpsuit?
I don't want to spend it one time on the bar, Your Honor.
Well, sir, it's interesting because you're one of the few that doesn't have a juvenile history. But then we get into the adult history. 26 times you've been convicted. You've had multiple plea agreements. You even had Hyde at one point to earn a non-public record, and you failed at that. We've got 26 times you've been convicted. And you're just learning now that you're finally going to take it seriously?
Yes, Your Honor. I'm to be honest with you, I just really realized that I have the ability to say no. I never recognized that before.
So the other 25 times you told that to judges, you didn't really mean it. Because this isn't the first time you said that, is it?
No, this is really the first time I actually said that, Your Honor. I mean, I've been going through this a lot, and it's like certain situations, you lose everything. I lost my parents. I lost a house that they left to me, and the loss of relationships, loss of having family ties severed, and it's just to continue to go through this and have this redundant thing is just really weighing on me. I had time to reflect, time that I took to reflect that I never took serious before. It wasn't about me not caring. It's just I really didn't know how to care, Your Honor. I'm gonna be honest with you. I didn't know how. I didn't know that my life meant something to other people. I got a young daughter. She cries sometimes, Daddy, why you keep going to jail? And I never realized that my actions impacted others. I just thought I was just hurting myself. And sometimes I get into the concept like, saying nobody cares. I'm just out here living my life, and what I'm saying, I'll be okay. But once you get older and older, start getting gray hairs, my hair not growing back no more. And I'm starting to realize, well, you have the ability to stop doing what you do, and nobody can make you do that. Only you can.
So how are your sons doing? You have two sons. One's 25 and must be, 27 now?
Yeah.
We'll change that. And the other was 25. It was 23 when this was written. And you got a 12-year-old.
Yeah, 13.
13? So you haven't been around much to raise these kids.
Surprisingly, they doing good. They doing-
Except every time someone says, how's your daddy doing? They're saying he's in prison. Is that what you want for that?
No. I'm pretty sure that's not my parents' money. To eat.
I'm pretty sure you're correct. When you were adopted, you were chosen to live in a family. It looks to me like you had a good upbringing. Is that right? And so why are you disrespecting everybody? The police, your community, your family? What's going on with you? Why? Have you ever asked yourself that?
Yeah, I did.
So what are you angry at?
I'm angry at myself. A lot of times, like I get angry at myself. I get frustrated by not using the talents that I know I had to use, and when I don't do them and I regress, it just adds to the problem because I just get in forget everything mode. And once I get into that mode and I go so far down that road, it's hard to come back. And I've been down this road so long, and I severed so many ties. It's hard to get assistance doing what I was doing, you know. And then, like I said before, I didn't know how to make proper steps towards correcting my problem, Your Honor. As many times as I've been in rehab and jail, I never understood the concept of just say no.
Well, it's interesting. You know the alphabet?
Yes.
LMNO. God put NO together in the alphabet for a reason. It spells no. Does that give you a little clue?
Yes.
No is the right answer. Start saying no to all the bad things and yes to yourself, because the only one that gets put down is you. You're not a big man around town. When you do all this, you are a little man. Can't follow the law, can't be a role model, has a lot of excuses. You're not taking pride in yourself, your family, or your community. You're tearing everybody down, including yourself. So I don't know how the adoption came about, but you were chosen by that family. You were supposed to be raised by that family and have a good life. And you basically spit in the wind at everything that was given to you. And it's come back on you. So the only one who can change that is you. Because I got to tell you, sir, when I look at this, I'm thinking, I don't know, I should go top of the guidelines. He hasn't learned his lesson yet. And top of the guidelines for you, and it's only recommended, I could even do more. Top of the guidelines on the one count is 38 months. I could go, instead of the 3 years and 2 months, I could go 60 months. You want 5 more years? Are you sure? Well, I gotta tell you, with this record, if I see you back in my courtroom, it'll be a long time before you get out. You have predetermined decisions like that, but I want you to know that this is a warning. At some point, with 26 times that you have been in front of a judge in a jump suit, with the failed attempts that you've made, I'm not sure why you get another opportunity. So your work has run out. So I'm not the only judge that feels like this. So you're a gambler. Go ahead, break the laws. At some point, you're never going to get out of prison. Never. So if you want to die there, look around and think about that. Or do you want to live a free man, making amends? You want to be a free man? How are you going to do that?
By saying no, using the alphabet.
Well, now you're never going to forget it. Is there any restitution that's due? I don't see any, but it looks like
I don't see any either, Your Honor, but
there was $10 in candy and Aquafina. I don't know if they want their $13 back.
I'm not seeing a victim impact statement, Your Honor, but I would agree that it's around $13 in regards to the candy and the water.
And was that Myers?
No, Your Honor, that is Admiral Gas Station.
Oh, the gas station, okay. Sir, you're going to be remanded to the Michigan Department of Corrections for 17 months to 120 months. This will run concurrent with what you are now, sir. You'll pay a crime victim assessment amount of $130 and $68 state costs. You'll also pay Admiral Gas Station through this court, so we keep track of it, $12.99. That's the total for candy and the water. Waiving fines, cost attorney fees, finding that you are indigent. While you are in the Department of Corrections, you will, I don't know if you've availed yourself of trade school and mental health treatment, cognitive behavioral, and any reentry programs, and substance abuse treatment. I imagine you've been doing those all along, but if we've missed something, then you'll do all those. You have 42 days to appeal to request appellate counsel. Sir, you're lucky I'm not giving you 36 months more. Don't be in my courtroom again. Someday you come back and show me the great things you have done and are capable of, because you are, and you're capable of all this. You're certainly capable of good things. Walking in the light on the dark side of the road, sir. Now, can you see your appellate rights?
Yes, I do.
All the record, thank you.
Just for clarification, Your Honor, you said 17 to what?
17 to 120 months.
Thank you.
And then he gets credit for the
363.
yeah, the three, I think that's right, 363.
City of Southfield versus Juwan Simmons.
Daniel Lover, City.
What's your name, sir? All right, Mr. Simmons, we're here for, let's see. Show cause for failure to pay fines and costs on a retail fraud third degree, which dates back to 2015. So you're here to show cause why you should not be found in contempt of court for failing to pay the money. Contempt of court is a misdemeanor, carries a maximum penalty of up to 93 days in jail, $7,500 fine. You have a right to have a full hearing or trial as to whether you're in contempt for failing to pay. You have a right to have a lawyer to represent you now or at the trial. If you couldn't afford a lawyer, you like one, you're eligible, we're going to make sure someone gets assigned to represent you. Okay. So basically you have some choices here as to the show cause. You could have the whole trial as to whether or not you're in violation by failing to pay. Well, I know, just wait. Or you could waive that right and plead guilty to violating the court's order to pay, in which case then we'd have to just sentence you. Or you could ask to speak to counsel, which case we would adjourn to assess your ability to pay for a lawyer and then get you a lawyer. Or you could just pay. And it's $512. And lucky you, this is the first day of amnesty. So without the extra fines, it would be $225 if you could pay it within this amnesty time frame.
I have your office on the other
Still in custody.
You don't have any family members that
I'm in there right now, man, for a $6,000 bond. And
they don't have $225 to take care of this for you?
they can go with the 6,000 get this. I'm still in custody.
I understand that. I'm not dealing with
Yeah.
I'm not dealing with the fact I can't do nothing about that part.
Like,
Because what are you in custody for?
I'm in custody of someone that receiving this, etc.
Okay. So that hasn't been taken care of yet. It's still in the process. So yeah, so they're trying to get by for that. But in the meantime, if they can get $225, this could just get closed.
You make the plan, yeah,
You what?
yes,
So do you think anybody could get you some $225?
yeah.
Okay, well, how soon could they get it? Because
Soon as I can get in contact with them.
because the amnesty goes to, I think it's today through May 1st. So gotta be paid in this time frame. So I mean, I could bring you back and see. You think they'd be able to do it within a week?
I've been in custody for almost 30 days now, so I was gonna ask them, can I get time served? And I still gotta go to court next month on the 20th, I'm still in custody.
Well, so you want me to give you time, you want to plead guilty, you want credit for time served and no fine. Because you can still get credit for time served and still have to pay the fine.
Still do that. Still pay the fine. Cause I did my work and I paid my fines last time I saw you.
So I guess my question is, you want to plead guilty or pay the fine, or you want me to adjourn it? So pay the fine.
Guilty and pay the fines.
Okay. All right. So I'm going to go over all these rights that you normally have. You have a right to have a full trial as to whether or not you're in contempt by failing to pay the money. So you understand you're waiving that. Fail to pay the money.
This was going, but
Okay, sir, let me explain what we're doing. You said you wanted to plead guilty to being in contempt of court. I offered to just adjourn this so you didn't plead guilty, but you said you want to plead guilty and pay the money. I said I can adjourn it till next week. You get the money paid, case is dismissed. So you opted to plead guilty and pay the money. So I said I got to go over the advice of rights. The rights that you normally have at a trial on contempt. Do you understand what I'm saying? So these are the rights I'm going over now. If you understand the rights, you say yes. After each right, I understand it. And if you have a question, feel free to post a question.
Okay.
And if you wanted a lawyer, you shouldn't want to talk to a lawyer.
Yeah, I want to talk to him.
You what?
I want to.
Okay. Well, that's going to require us to get an adjournment anyway, because they're not here. We don't have lawyers like we used to way back in the day. We could just say, here, come on, come on. So you're going to have to fill out a form. We'll have to come back. You sound like you're in a rush to just get this done.
I just started a new job into this other situation. I just got fired, so it was like she kept me on court, so it's really hard. I'm in custody. I can't take care of nothing if I'm in custody. I just had a good job. She kept me in custody for $6,000. So I got it, and then the good cash I does have is in Farmington Hills and they property, so it's hard for me to get in contact with my family. I really don't have family.
So who's gonna pay the $225?
That's the issue. My sister, I gotta see if I can get her to get my property. So I'm Farmington Hills to give me all my little debit card I have. That's the issue I've been having. That's why I'm still in custody.
I see. Have you been able to call your sister?
I talked to her a few times. I told her I was going to court today, so she was like, let her know what's going on. She was like,
Well, perhaps she has, maybe she doesn't, but maybe she has $200 she could put towards this until you can get your money and you can give it back to her.
oh, but she does have $200 to put with the other bill too.
No.
I'm talking about with this too.
Oh, you're talking about 225 for this and then have six. I don't know if she got 6,000. She might have to contact a bail bondsman.
Why not? Since I've been incarcerated, because I'm not getting out, so anytime I go to court on the 20th of next month. Is there no way I can just do time? Cause I don't get out. I'm not getting out to get it. And my sister, I don't even know if she got it.
Okay. Well, that's what we were taking your plea for, is to give you some jail time. And you said you're going to be able to pay the $225. So we're going to do that and assess the fine, and you pay it for a certain date at the reduced rate. That's what we were going to do. However, it's up to you how you want to proceed. And that's why I suggested, well, maybe you want to talk to a lawyer. Maybe you need some advice. I don't know.
I can't pay for it till I basically like get out, because my sister, I'm actually, when I get there and if she have it, I can get it paid. But only thing I can count on is me getting out and returning to work and making a payment as far as that.
Well, I don't know why you didn't pay this, because you had to have had it. Just go back to 2015. That's 10 years ago.
I shot it. I stuck with one.
Listen, let me tell you this. This was $150 fine that you were supposed to pay by February 3rd of 2015. You done got all the way up to whatever I said. 500 now.
Push it up to 100.
No, they can't push the fine up. It's assessed. The fine gets assessed interest and penalties. That's what happened. So, and you said that was January 26th of 15. You said you had $150 by February 3rd of 15. We didn't give you no jail time. We just fined you. It was the easiest sentence in the world, and you messed that up. And you sound like you make some bad decisions.
I make bad decisions.
And this was from, see if you're going back to here. Kroger. Merchandise from Kroger on Greenfield. Offered for a sale price of $7.49. That just sounds crazy, doesn't it? You took something that was worth $7.49. Got caught, got convicted, got a fine that was way more than $7, but not as bad as it could have been, up to $500. You got $150. Didn't get that paid. Then nobody's seen you in 10, 11 years.
I did jail time.
Sir, let me tell you something. Looking at what I wrote, there's no jail time. You might have been in custody. I didn't see no credit. There's nothing written here. I didn't sentence you to jail. So maybe you got arrested, maybe you got out, but you were out and signed a notice that you were going to pay your money by February 3rd. So I don't know what crime you getting this one confused with. Recommended Don King was the courtroom attorney back then. Recommended fine, no jail.
Yeah.
So you got no jail.
No, I'm gonna pay it as soon as I get released. I got it. It's in my property. I can't even. I'm afraid that I can contact my sister to give my property for $5 million, and I will pay it. I have it with my property. I had the $250 on my property. It's on my child.
Hey, we don't know when you're gonna get released. That's the problem. You don't know, right? Well, I can do this. Well, we don't know. So that doesn't make much sense to just adjourn it. I can adjourn it if you think your sister can pay it up front and you can pay her back. Then when we come back, it'll just be paid. I can dismiss it. I can do that. Or you could plead guilty. I could sentence you to something with a fine and give you a date to get it paid by.
That's my sister.
So you want me to adjourn this date, have you come back and see if your sister could pay it? Or do you want to plead guilty? And I just give you a date to get it paid by and give you credit for time served or something. Okay, I'm going to try this again. Do you understand you got a right to have a trial on whether or not you're in contempt of court for failing to pay the fine? At that trial, you have the right to have an attorney to represent you. If you couldn't afford a lawyer, we'd make sure someone was assigned to represent you. You understand? You're going to waive that right. You would also have the right to question any witness that was brought against you at the trial. You understand? You're going to waive that. You also have a right to subpoena any witnesses that you would like to testify for you at the trial. You understand? You're waiving that. You also have a right to testify on your own behalf. But if you chose not to testify at the trial, then no one could hold that part against you at all. You understand that? Waiving that. Also, you have the right to be presumed innocent unless you are proven guilty beyond a reasonable doubt at trial. You understand? You're waiving that. If you're on probation or parole, contempt might possibly violate your probation or parole. You understand that? And we didn't give you a full advice rights form to read, but we can. All right, so you did read and sign an advice rights form now? Did you have any questions about anything on the form?
Okay.
I understand if I do accept the plea today, you will not have a trial and you'll be giving up the rights that are listed here.
That's right.
And you also understand the possible penalties on the contempt charge could be up to 93 days and a $7,500 fine. Still wish to plead guilty to that charge. Anybody force or threaten you? You've been promised anything at all? And you're pleading freely and voluntarily, is that correct? All right, so it's true then that you were convicted of this retail fraud 3rd degree. And it looks like it was back on January 26, 2015, and the court assessed a fine of $150 and gave you till February 3rd, 2015 to pay, and you never paid. Is that correct? Mm-hmm. That's sufficient factual basis for this plea. Court will have been complied with. I find the plea is freely, understandingly, voluntarily, accurately, and knowingly. So we'll accept that plea to the contempt. So I'm looking back at my notes from back when we did take this plea, and the notes from the prosecutor at that time said you were on parole and you were reporting to the parole officer that day.
Got locked up.
What were you on parole for? Okay. So, okay. 11 years later, you still locked up. What's going on with your life? How old are you now?
45.
And you just had a good job.
I was going through a lot of my past and everything in the streets.
Yeah.
That's just a lifestyle.
How old were you when your mother passed?
But the past, like 4 years ago, I was 41.
Okay. Well, you were grown. Nobody's ever ready for their mother to pass. Truly, I get that. But it wasn't like you needed her guidance every day. Well, how did you get off into the streets before that? Did she try to stop you? Why didn't you listen to her? See, that's the problem. You got parents that try. There's only so much they can do, especially with a young boy. You were a boy. Where was your dad? Was he around? And boys just need male guidance sometimes. Not that mothers can't do a job, but they're not a man. So they can't appeal to your male senses. they can just appeal to your senses. Because you got male senses that boys need another man, like a pack. I hate to say this, like a pack of dogs. You know, they need a leader. Someone that they respect, look up to, and that they want to please. You didn't have that. So you found it in the streets with the pack of kids that was doing wrong. And maybe you thought that you could make a name for yourself that way and they look up to you. But guess what? You ain't the only one that's been there. It's never too late to change. So don't give up your hope. You've got to stop making bad decisions. You got to clean up your past. All of this stuff that's haunting you. How this is little next to that. But when you look back where you were 10 years ago in your 30s and you're stealing something from Kroger for $7, it's like, okay, why? Whatever it was for $7, you ain't need it. You're just in there doing something. Saw something, decide, hey, why not? You gotta stop doing that because you're wasting your own life behind these bars. And then by the time you get out, you're 10 years older, 5 years old, whatever, and you haven't accomplished anything. And believe it or not, everybody's life is here for a reason, to accomplish something. Nobody's born to go sit in prison. I think that's what the purpose of your life was. But see, when we were born, we were given free will. We were given a handbook on what to do. That's the Bible, from my perspective. You can read that Bible, go to Sunday school, learn the lessons, whatever, or go the other way and live in this world. But if you haven't checked lately, this world is messed up. It's totally, we have just ruined everything. And that's why, it's going to be the end of it. And you can see it coming. It's happening. Everything's imploding slowly but surely, actually kind of fast now in this country. It's never going to be like what it was. And then if you're a good Christian, which I am, God comes back. He's going to wash away all of this mess, though. So the question would be for you is, what did you do to redeem yourself? So you're not perfect. But who is? And so I think that God understood that. That's why we gave us a son. That's why he died. So that we could all be saved and redeemed. And guess what? He showed us he can come back beyond the grave. That's what we just celebrated a couple days back. Everlasting life, which we get to claim because of him. So guess what? You got to fix this. You got to get it right. You don't have to get right with nobody but God. And pray on it. Ask for the forgiveness and ask for some guidance and some direction for the rest of your life. Because you've gone through a lot. And just maybe the reason you did might be so that you could help some of these little young kids that don't get it, that's looking for somebody to look up to, and they doing the same thing. Trust me, all of this stuff is repetitive. It's a lot of evil because, the devil was a fallen angel and he got thrown down here. That's why it's all chaos. And now he don't care if we know it. It's all in the music videos. Everybody got on devil horns now in Hollywood. They doing rituals in the music video. And I'm looking at it. See, when you're a child of God, you can see it all happening. Other people just think, hey, this is entertainment. It's not. This is him putting his hand on all of our youth. They don't like us because we made in God's image. So you won't let him win and get you? You want God to get you. So you can't let the devil get you. So that's why you got to pray on this. And what you think being in is a really bad thing, it might not be the best thing, but it's a good time to think. It's a good time to get out your legal pad and your pencil that they give you. You draw a line in the center of your pad. And on the one side, you write down everything that you would like to change with your life. And on the other side, you just draw an arrow and you start writing for the number one thing, draw your arrow. Just what I need to do to fix this. For the number two thing, draw your arrow. That's what I need to do to fix that. And you just keep going. Fold that paper up, put it in your pocket. Look at it every day. That's your life plan. You didn't get yourself into this overnight. This has been a lifestyle for you. So these steps will be slow steps, but they're slow, steady steps. And you pray along the way. Hey, I'm sorry I got myself into this. I want to be that kind of man that my mom wanted me to be. I want to be a God-fearing man. I want to walk in God's light in his footsteps as best I can, being a broken man, because we all broken. God, just guide me. Give me the strength. Give me the wisdom. Give me the vision. Do it. Before you know it, you'll be out. Then when you get out, take your life more seriously. Look at what you have to offer. You seem like a nice guy. Just nobody talked to you the right way. Mom did. She tried. You wasn't listening. And by the time you was ready to listen, she gone. Never too late to listen. 40, 50, whatever. You have people 60, 70 going back to high school, graduating, going to college, graduating, and more. Some old people graduating from law school just because they wanted to. So nothing is beyond your accomplishment. But the only thing holding you back is you. Because you just got to stop shooting yourself in the foot. Every time you take a step forward, you got here you go. I don't even know what this instructing case is you say you're in for now, but that's one you don't have to have. You just stop and listen to what they say and do it. Whether they right or wrong, just do it. Fight the battle in the courtroom, not on the street. So, but you got to be ready up here in your heart. You be ready for the change. You got to be sick and tired of this life that you done made for yourself down here in this little evil earth we got going right here. You got to be sick of it. Pull yourself up by the bootstraps. You don't need your mother to be here. You already know what she would say. She already with you. She been with you. If you were to talk to her right now and ask her, Mom, what you think about this and this and this and what I did and what should I do? You'd get an answer in your own head because you already know what she would say. So don't be sad about her because she hopefully in a real good spot. She in the spot you aspire to get to, hopefully. But if you keep making the bad decisions, you don't have a chance to get there. But you can have done some bad things and get there. No question about it. Yep. And then you can do all these great things and not get there. It's all about your mindset. Do you fear God? Do you ask for forgiveness? Do you humble yourself before Him? That's what it's about. So, there's probably murderers in heaven because they have made the step to change. And they've asked for that forgiveness. Ain't no sin too great for God. So you already know you're good if you make yourself good. So hopefully you've gotten something out of this today. I like to say sometimes you come to court and you get some enlightenment in a way you didn't think you were going to get it. Because, you can go to jail 1,000,000 times. What's that do for you?
I got some enlightenment today from you.
Yeah.
Appreciate it.
Yeah. Well, you know why? Because I'm going to tell you why. When I came on this bench, 20, 30 years ago, I had an epiphany because I already knew I got here under strange circumstances. And I said, I'm supposed to be here. I wasn't exactly sure why, but then I kind of figured it out. So what I did was I just put a little reminder to myself that when people stand, it's not for me, it's for the process, the majesty of the judicial system. It's not for the person. They just give the respect through standing for the person. So I always ask to be able to say something that might change your life. And what I did was this here 23, you can see it. Because I can't see it because it's so, look how faded it is. It's the old sticky. What does that say? It says, in the name of Jesus. Been here 23 years. So if I were to ever think that any of this is about me, it's a reminder that it's not. You say and you do what you can to rehabilitate us. You know, we're not here to put everybody in jail. Do we do that? Yeah. Because sometimes people got to go. But other times you do and say what you can to just get a breakthrough. We don't know if we get a breakthrough or not. Sometimes we do, sometimes we don't. Well, or if we do, we don't hear about it. But it doesn't matter because we say what we need to say in order to help. So hopefully you get a little help, you get a little guidance, you get a little forethought so that when you take your next steps, when you do get out, you know every step matters, it means something, and it's got focus and a direction towards your future. And you don't let nobody out here in this world, in these streets, pull you off of your direction. You're going to get sidetracked by quick money, drugs, alcohol, parties, stuff that, what good is that doing? You know, and the thing about this whole thing is, and I'm thinking about just life, period. The whole thing about it is you got choices to make. You know, you can have fun. Nobody said you can't. But the bottom line is, fun traded at what expense and when? So that's what you got to decide. And get rid of the people that's not doing nothing for you in your life. You know, you talking about, I ain't really got no family. But where are them friends you was hanging out with when you got into some of this trouble? Where they at? You know? Think about it. Those are the ones you would like to think, oh, they'll be here. No, they're going to be the first ones that run when the police come. Right? Leave you hanging there. Well, that's my boy, but hey, I can preserve myself. I'm gone. So they're not here to pay your $225, are they? They ain't paying the $6,000 bond either. So make better choices with your friends. And if you don't hang out at 41, you've done enough. You've seen a lot. You don't have to hang like that. Now it's time to get focused about you, your job, your career, your future, family. You got kids?
Yeah.
How many you got? How old are they?
One just turned, June turned 11 on the 4th.
Okay, well, don't you think he need a daddy?
Yes, ma'am.
All right then. 11? So what he think you are?
But they want to let him know.
So what you do is you talk to him about it when you're ready. And you just tell him you made missteps, but I figured it out. And I don't ever want you to make these missteps. He'll appreciate that. Because you're the only daddy he got anyway. Right? So he gotta love you regardless. And he will love and appreciate you because he'll be able to say, look, my daddy did this and this and this. He started out, he did that, but he turned it around. Look at him now. He could be proud of that. How's the other one?
13.
Oh boy, you wanted to pick a man like you? Do you?
No.
So turn into the guy you wanted to pick. that she's getting to be that little age that they're starting to grow up now. You still got a little time to work with them, though. So just look at what you got. Everything that matters right there. It's right there. I don't think you blind because you ain't saying it.
I said, like you said, I'm looking back to say this thing for change.
Good. This is the first day of the rest of your life, right? So make it a Renaissance day. That means rebirth. That's what you got to do. Well, let's see here. What we gonna do? I guess I'm gonna ask the people. Do they wish to make any statement? You really taught him well. Thank you so much. All right. So let's see. What are we gonna do here? So, Mrs. Simmons, you've been here since the 23rd. You've been in custody. So, Mr. what? Oh, well, I didn't arraign you till the 23rd. I give you at least till the 23rd. So, let's see what we did. And you don't know when you're getting out on the other matters.
Yeah, by my birthday, hopefully.
When is that?
I remember the part, yes.
You're Aries man.
Yes, man.
What's wrong with you? You know something about some Aries people, because I'm one of them. You done got the wrong one now. Shoot, that's not Aries behavior. Well, you can get misguided and directed, and we lead with the head. You got them big horns on the rim. And it's the first sign of the zodiac. Did you know that? So it's like an infant. It doesn't have any prior lessons that it's learned. So all of its lessons are in front of them. So you butt your head a lot, making mistakes. And I don't know what your other parts of your sign is, but I just know that you're smart, resilient, youthful, funny, charming sometimes, hard-headed. Sometimes you get mad, but you don't hold a grudge. You say what you mean what you say, and you're moving on. I listen, so I might have something different going on than you did when I was young. I didn't want to deal with my parents like that. Nope. Wasn't messing with them. You mess with your mama, and she trying to hold you down. Mm-mm. Did stay on you, and I'm sure she tried.
So.
But the bottom line is, you got the ability. You can be creative. Once you decide, I'm gonna tell you what I know about an Aries. Once you decide something, ain't nothing gonna stop you from doing it.
Right.
But you haven't decided nothing. You're just sitting. What, you in a slump?
Surrounding myself with bad people, like you said, I have been making a bad decision, partying, drinking, drugging, and all that, taking death from my mother hard, family problems. I started making change before I got incarcerated. I did get a good job. That was what they began. Start talking, be active with my kids. But this ain't honeymoon. It got right back in front of you. Which I'm glad that you gave me the speech and talked to me because it gave me the chance to realize it's another chance.
It is another chance. And it ain't coming from me. It's coming from above. So you just gotta be thankful and prayerful for that. Yeah. You just gotta want it. Do your part, because you got the free will to do the part. Okay. So this one I'm gonna do. Now you still on Ashton?
Yes, man.
Is this phone number correct? The one ending in 2606? You have one number you could be reached at or no?
2-5-595-3401.
Okay, so sentence to the court, 16 days in jail, credit for 16 days. I'm gonna waive the penalties and interest, and you're gonna pay the original $225, fines and costs. I'm gonna refer this to the collections clerk for collection. It might come up and talk to you while you're here. Because we're gonna have him take the file down. And then that's gonna complete this matter. Okay. Good luck. Yeah.
This is State of Michigan versus Jasmine Collins. 24-01314 appearance, please.
Thank you, Your Honor. May I please report Assistant Prosecutor Stan Smith appearing on behalf of the people. Assistant Public Defender Joseph Hardy on behalf of Ms. Collins, who is apparently a polycom.
Ms. Collins, can you hear us?
I can.
Can you stand up and move your body so the light comes on? Okay, thank you. Today was the date that was scheduled for a final pre-trial. This is for an assault and battery. Do we have the necessary witness here? Or were you aware that there was going to be a final pre-trial today? I think he was remanded on this. Okay, very good.
I was aware.
Okay,
And the complaining witness is here, seated in the front row of the courtroom.
very good. How are we proceeding?
Yeah, the city has extended an, well, not an offer, but
Not the city.
or the state,
I get it. Said he was yesterday.
Yep, still on Monday status. So basically, we have a plea offer here, permission to approach your honor. It's kind of be pleading as charged with ignorance and what material.
If Ms. Collins wants to plead guilty to the assault and battery.
That's correct. That's the people's understanding.
Oh, that's ridiculous. She had an offer before, disorderly conduct. No objection to Haida.
That offer has been withdrawn. They've been made a new offer, and it appears as if they've accepted the new offer.
Yep, that was the case at the time. I counseled with her. No, I can't speak to reasonings for not, agreeing to that offer at the time. However, since the offer is revoked, she's agreed to the previous charge.
When was the offer revoked?
Well, Your Honor, if I may, I would have to say, since I came to the court and I've reviewed the charges, I determined that an assault is more appropriate in this case. So, and I've just recently conveyed that offer to him, I believe, by email yesterday or the day before.
So she's offered something and you took over the case and changed. There's a reason why I write the offer down is to avoid the changes because they changed the prosecutor. Because that's improper. There needs to be continuity. Now, if you're saying that it was revoked because she failed to appear for 2 years, that's reasonable. But because you came in and reviewed the file and thought something else was more appropriate, it's not appropriate. Because the prosecutor who was here before found it appropriate, extended the offer. We have had countless meetings with both your office and the city attorney's office to make sure we avoid that. What we don't want in court is just because a different prosecutor is on it, the offer is changing. We want continuity. Now, I can understand it being withdrawn or revoked and you being notified or your predecessor, because you weren't on this case then either, because she failed to appear for almost 2 years. But the position of I've never seen a prosecutor revoke an offer. You all are trying to give the same offer at the day of trial.
Again, I think the offers that I give, Your Honor, will be subject to change if that offer is not accepted by the defendant and the court on the day that the offer is given. So any other time, on any
It's
other
not the day that it's given.
on any other case, my
We don't,
position at
they're
this
not
point-
required to plead the day the offer is given.
Well, my position is, if it's not accepted when it's extended, then it's subject to change.
Yeah, the position and the policy of the court is there's offer and extended, it's held open until the final pretrial. And then at that time, it's revoked. She had a final pretrial that she failed to appear for 2 years ago. That's why I said that if that was your reasoning, I find that to be reasonable. But not just because you didn't like the previous offer.
Well, this is the final pretrial.
The offer that I was given.
She has until today to take the offer.
I will.
So again, if the court is not prepared to take the offer at the time because it doesn't find the offer acceptable, then we can proceed to trial.
No, it's not, the court is not prepared. The offer, I'm trying to find out when was the offer revoked? Because there was an offer that was given and communicated to her of plea to a disorderly jostling and no objection to sentencing under HYTA. That offer was communicated, and then now there's a new offer that is not as pleasing as the other offer. So I'm trying to find out when and how this previous offer was revoked.
What I'll say, Your Honor, is that I think your notes are better than the ones that I'm going through, because there was not any knowledge to me of when I said that it was revoked. That's something that I learned. As far as offers that I had received, not any of my predecessors, it was just the assault and battery.
Okay, so you weren't told that the previous offer was revoked. You was just given another offer.
Yeah, he said that it was revoked. That's what I was referring to. But
What do you mean he said it? You mean today on the record?
yeah, today on the record.
That's what I'm trying to get to the bottom of. Which would be improper. That's why we give the offers on the record. That's why I do it. And it's open until she has until the final pretrial to accept that offer, which is today. It's been the policy of this court forever.
Well, we would of course have no objection to the better offer of disorderly. It would be allowed to enter that.
It wasn't properly revoked. You weren't notified that, oh, there was a previous offer and we're revoking it for X, Y, and Z. They just tried to give you a different offer because they didn't keep an accurate note of what the offer was, or your office didn't keep an accurate note of what the offer was. And we've already went through this with the office of the prosecutor. We're not doing different offers on different days because they keep changing the prosecutor every other month. We're not doing that. That's not appropriate. So you all can discuss that further, then you can counsel with your client. I'll recall the case when you have an opportunity to do that. I'm back on the record in the matter of the state of Michigan. Jasmine Collins, what are we doing?
I spoke with prosecution and confirmed that the only offer that's open right now is the plea discharge to the assault and battery, to no upfront jail. We would like to continue down that path.
To plead to the original charge.
Yes.
Is that correct, ma'am?
That's correct.
Excuse me? Can you say it again? I couldn't hear you.
Yeah,
Okay,
that's correct.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can put your hand down. Okay, you understand you have the right to proceed to trial on this matter.
Yes, I do.
Okay, you have the right to be presumed innocent until proven guilty. I didn't hear a response. You understand that?
Yes, I heard what you said. Yeah.
Okay, And so that means that you have the right to see, hear, or question any witness called to testify against you, the right to call your own witnesses or present evidence that you believe show a defense to the charge. You understand that?
Yes.
Okay. And the right to remain silent and they can't use it against you. And you're willing to give up each of these rights?
Yes.
Anyone threatening you to do that?
No.
Any promises made to get you to plead guilty to the charge?
No.
Are you pleading guilty to assault and battery because you believe you're guilty?
Yes.
Okay. You're not on probation, correct? Okay, you understand that guilty plea could result in a conviction that you might need to report to your employer?
Yes.
Okay. As to assault and battery, how do you plead?
Yeah.
I can't hear you. It's picking up. It's like an echo or something. How do you plead?
Guilty.
Okay, tell me what you did to make you guilty of assault and battery.
I went to Harbana and I fought that girl.
You went to where?
I said I was at Harbana and I beat that girl up.
What's Harbana?
It's a weed shop.
Where is it located?
That's Saginaw, or maybe it's on Saginaw somewhere.
Is that in Lansing?
Yep.
Ingham County?
I think so.
Okay. And you say you beat that girl up?
Yes.
Do you know her name?
Alexandria, I think that's it.
Okay. Why'd you beat her up?
Well, we was having a little squabble over Facebook Messenger.
Okay. It was not in self-defense, correct?
It was not.
Okay. But for the record, what's a squabble?
Like us arguing over Facebook.
Oh, okay. Any other questions?
The people were satisfied. Now that we got the squabble definition, I think that's it.
That you just wanted to make the record clear. Okay. If court satisfied with the factual basis, I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. It's been held on this since the second.
I believe it was 37 days, I believe.
Is the victim here?
Yes, the victim is present on the first row of the court right here.
Would the victim like to make a statement first, or any objection to immediate sentencing?
No objection.
Would she like to make a statement at all? Can I have a criminal history, please?
Yeah.
Okay, and she can take her time to decide if she wants to make a statement while I get the criminal history. Mr. Benson has been here for some time. We need to address this matter. That's a show cause. Mr. Benson?
Yes, ma'am.
Okay, State of Michigan versus Martin Benson 20-03538. Mr. Benson, you owe us $470.
Yes.
What's going on?
I hadn't started working the last time I was in court, but I have made payment since then. I paid on the 24th, and I'll be paying this month as well.
What did you pay on the 24th?
$43.
$43?
Yes, ma'am.
Okay, because I think your previous payment plan was $50 per month. So are you looking to do $40 per month?
Yes, if it's possible.
Okay, I'll note that in the file. You continue with your monthly payments. You're all set.
Okay, thank you.
Thank you. Back on the record of the matter for Jasmine Collins. Just the victim to make a statement.
Your Honor, Anna Buckingham, on behalf of the people requesting to practice under 8.120 for the remainder of sentencing, if you would allow. After speaking to the victim.
Motion granted.
Your Honor, after speaking with the victim, she had asked that I could make a statement on her behalf. Would you be willing? Thank you. So the issue in the squabble that Ms. Collins talked about earlier, it all really circulated around her ex-boyfriend and the victim's current boyfriend of a few years. Because of that, the victim is concerned. The Urbana location is the employment place of our victim in this case.
You said the Vaughn what?
The location that you had asked.
Oh,
about,
of the incident. Got it.
Is the location where the victim in this case works. And this all started as an argument over that gentleman who is Mr. Give me one moment. Okay, Mr. Hunter Parcello. The victim is just asking that no matter what your honor sees fit and imposes, that hopefully there could be a no contact order that continues both for her and her boyfriend, Mr. Parcello. If you're not willing to do that, at least for the victim in this case, she is concerned that the arguments will continue. She doesn't want to cross paths for the duration of any probation imposed.
Ms. Collins is currently employed at 2 locations, both a Taco Bell and also chocolate smoothie. She is looking to get past that. She understands that what she did was a bad judgment call. However, I don't believe that she is a danger to the community at all, and I don't think that any type of further supervision is necessary. She currently, I believe, has 37 days credit. So we just ask that she be given a sentence of 37 days minus 37 days credit.
Isn't she eligible for, otherwise eligible for sentencing?
Fine. I mean, for Haida, I guess it was my understanding that the prosecution would not consent to Haida, but we would definitely request that if the court allows.
They never objected. They actually offered it originally. So.
Or it's our understanding the prosecution consent is mandatory 21 to 25 years old. We did not consent. She is 21 at this time.
He did consent because it was an offer. Just because they didn't push the envelope doesn't mean that wasn't an offer from your office in this court that was not properly revoked.
Under the Breakout. Yeah. To make it clear, currently we do not consent to Haida, but obviously it's your court.
We have records that show that they did consent.
Okay. Well, in that case, we would request Haida to allow her to keep this off her record and preserve.
Did she want to make a statement?
Is there anything you want to say?
No. I would be very clear. I don't believe that she has any remorse for her actions. I don't think the things that you said, I thought they sounded nice from you. They didn't come from her. I watched her body language, even as the matter, as you were speaking on her behalf. Even the way she demonstrated or discussed the incident when I asked her to tell me what she did, it was very matter of fact, laissez-faire. I beat that girl up. There's no
supposed to explain it.
I don't even understand why she's talking while I'm talking. There's clear here a misunderstanding on how to respect people, a misunderstanding or a lack of ability of self-control. The fact that a judge is speaking and you just start blurting out over them, unless you have Tourette's, you lack self-control. When you were speaking, no one cut you off. So even if she didn't know any better, she could have watched the example that was given. Didn't happen. Again, I watched her language the entire time. I don't believe that she has any remorse for her actions. I think she believes just that her actions were justified or just a regular course of everyday life. And young ladies shouldn't carry themselves in that regard. I don't care what the nature of the relationship is between her and the victim and her and the victim's boyfriend. Who cares? You don't need this. You shouldn't be showing up people's jobs squabbling up as a 21-year-old young lady. You should be at your own job. It looks like you got 2 of them. Should be too busy to be trying to squabble up with somebody. Now you've been sitting in a jail for 30 days. ridiculous. I think that she needs to do a term of probation with court oversight. And I will continue the no contact order. I can only continue it as to the victim. I can't continue it to the other person because he's not a victim in this matter. Nor was he even named in the underlying affidavit. So I can't do that. So there's a no contact order that will continue. You're not to have contact directly or indirectly with Alexandra. Is it Zerdine?
Zerdin, yeah.
Zerdin, okay. Are you not to be within 2,000 feet of wherever she lives, works, or goes to school? While on probation, you're not to use, purchase, or possess alcohol, drugs, or marijuana. You will be required to submit to random urinalysis testing. And you have to pay the cost of that. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. I am going to order that you complete an anger management group and more recognition program. You need to do that within 90 days. And provide evidence of that to probation. You need to maintain your employment. You're not to be at any bars or any nightclubs while you're on probation. Do you have any questions at this time?
No, I do not.
Just so we're clear, assaultive and threatening behavior would include a squabble. Okay? You don't have to squabble up with anybody. You understand that?
I understand.
Alexandria, correct? Okay, thank you. There's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that will be assessed. There's a $30 per month oversight fee for each month of probation. I don't know if I said it, but it's going to be 6 months of probation. She's not eligible to request early discharge because she's on a probation for an assaulted action.
Will this be higher probation here?
I will grant sentencing under HYTA.
Thank you.
I'm going to waive discretionary fines and costs at this time. So she just has the crime victim rights fee and the state minimum cost and then the oversight fees. For a total of $305. She's responsible for monthly payments on that. Do you have any questions at this time?
Do I have a bond?
You don't have a bond because you're being sentenced, so you can be released to serve the sentence now. You need to report to probation within 48 hours of your release in person at the court.
Okay.
You have any other questions?
No, I don't think so. You said I don't have a bond, so what is
You
that?
don't need a bond because you're now being sentenced, so that once we just put a disposition in, you're not being held on the bond. You're gonna be released now to serve a term of probation.
Oh, okay. Okay, well then, yeah, I have no more questions. Thank you.
Okay, you're all set. Thank you. This is case number. This is case number 250-583-0001 versus Tamara Joy Ford. Defendant is charged with malicious destruction of property and something dealing with a motor vehicle. Today is the day set for restitution hearing. Restitution and contempt of court hearing. Appearances.
Good morning, Your Honor. Delisha Taylor Coleman, on behalf of the city of Detroit.
Good morning, Your Honor. Clarissa Grimes, P82965, the Neighborhood Defender Service, on behalf of Ms. Ford. Can you state your full name, please?
Tamara Joy Ford.
All right, let's start with the restitution hearing. Today is day set for the restitution hearing, and I believe you all have reached an agreement.
Yes, Your Honor. At this time, Ms. Ford would agree to pay the medical bills, the amount of $704.39.
$704.39.
Yes, $704.39.
So the court will, I apologize, is that a proper stipulation, counsel?
Yes, that's correct.
Court will set restitution at $704.39. Ms. Flanagan is going to prepare an minute order, which includes the restitution. And it will be added to the total fines, costs, and fees. All right. With respect to the contempt hearing, which really, let me change my language. Because it is not a contempt hearing. When the parties appeared before me at the last hearing date, it was quite contentious. Quite contentious. And at the conclusion of the matter, when Ms. Ford was logging off my Zoom, she comes at me, cursing. And I, on that day, held her in contempt of court. On the record, I said, she is held in contempt of court, but she hung up. So I'm changing my language with respect to a contempt hearing. The court on the record held her in contempt for cursing at me that day. So today the court is announcing its punishment for the contempt, which is why I indicated we were going to come in person for this restitution hearing. So I don't normally hold restitution hearings in person, but since Ms. Ford cursed at me, then we had to have this in person so that the court could announce its decision on the restitution. I mean, on the contempt punishment penalty. So, counsel, if you wish to be heard, you can be heard as to the penalty for your client cursing at me on Zoom.
Thank you, Your Honor. So unfortunately, I had also already logged off Zoom, so I was not present, did not witness what was going on. After being informed by the court what had happened, I discussed with my client, and she indicated to me that she was certainly not attempting to insult Your Honor, and so.
Because people shouldn't be insulted by people cursing at them?
I'm not sure if it was a misunderstanding, but regardless, my client is sincerely apologetic for any insults to the court. And so for that reason, in addition, my client has a young daughter who is in her primary care, who is at school right now. And
did she make arrangements for somebody to pick up her daughter?
I'm not sure, Your Honor. Okay. Your Honor, we understand the seriousness of this incident. Ms. Ford has learned a lot from this incident. We are asking, Your Honor, for something that does not involve jail. If there is an ability to either pay a fine or do something else that Your Honor would impose, that is what we'd be requesting today. So that her child's life is not obstructed. And my client has something she'd like to press on as well. She may.
First off, Your Honor, I just would like to sincere apologize to you. My daughter, she goes to therapy. She tries to commit suicide every other week. I definitely was not cursing at you. A person kept calling me.
Call Miss Tripper. Okay. If you're writing this transcript. You say you weren't cursing at me?
No, ma'am.
Okay.
No, ma'am. I was not cursing at you. I did curse, but it was for a call that kept coming in while I was on the Zoom with you guys.
So you cursed at your phone because you didn't put your phone on Do Not Disturb while you had a court hearing?
Yes.
So you want me to believe that all the while you were on Zoom with me with a nasty attitude, that at the end of the conclusion of the matter, when you cursed, that wasn't directed towards me?
No, ma'am, it was not. I mean, I agree that I did some, I was being disrespectful at the time, but I definitely did not curse at you. It was not it was for a phone call that I kept declining and they kept calling. I was not cursing at you, Judge.
You want me to believe that you were rude and disrespectful to me, but you would never curse at me?
Yes, because I wasn't cursing at you. I did disrespect you by taking a bite of my bagel and saying things to you as if, you know, you were not having a good day. But I was not cursing at you.
I think you actually said something about me not having a good day or something.
Yeah,
yeah, you did. And now I think you might not be having a good day today. I think maybe if you thought I was having a bad day that day, demanding respect in my courtroom that I'm going to demand every day. I got kids too. And I remember quitting the job because it was too stressful for me and my kids. It's one of the highest ranking people at the Detroit Police Department. I said, I can't do this. Why? Because I got kids. This stressful. I didn't go to work and take my stress out on the people that I worked with. I didn't take my stress out on the people that had to come to me for things. I didn't take my stress out on people who I was engaging with who had nothing to do with the things that were stressing me out. And so just like I told the other gentleman who came in my courtroom because he got rude with me and disrespectful and all of that to me on Zoom. When I wake up in the morning, talk to the one that I talk to in the morning, and put myself in a good mood, come to work and put on this black robe and these pearls, I don't do that to say, I can't wait for the people when they come in. I'll be so happy when they go off on me. People who I have had nothing to do with them being in my courtroom. I wasn't there when you committed your crime. I wasn't there when you got charged with your crime. I may not even been there when you took a plea in the felony courtroom for your crime. I had nothing to do with any of that. Yet you come in here and you gonna eat a bagel on my Zoom courtroom like that's appropriate. Let's just invite the public in and tell them to bring their breakfast, ma'am. This is court. And you were quite disrespectful to me. And now that you need to pay the consequences for your disrespect, you want me to believe that, yes, Judge, I was eating. Yes, Judge, I was getting smart with you. Yes, Judge, I was being disrespectful, but not in a million years would I ever curse at you. That don't make sense. But here's the thing about it. Whether you were cursing at me or just in the courtroom, whether you just forgot your mic was on, whether you didn't log off before you was cursing, either way, you cursed in my courtroom. You cursed in my courtroom, adding on to the already disrespect that you had displayed to me that day. Disrespect that I didn't deserve. Disrespect that I didn't ask you for. Disrespect that is unfair to me as a jurist. Court is going to impose following sentence for contempt 3 days in the Wayne County Jail held in abeyance. If you complete the terms and conditions of your probation successful without any other issues or hiccups, then you won't have to serve the 3 days. If you do, if you're gonna keep that same energy you had with me on Zoom, you're gonna go to jail for 3 days, and I'm not gonna be concerned about who's gonna watch your child. There's never gonna be a day that you're gonna come in here and I'm gonna care more about who's gonna watch your child than you. Because you weren't thinking about who gonna watch my child if she locked me up while I'm on here going off on her, being disrespectful, eating bagels and cursing. You didn't care about who's gonna watch your child. I'm not gonna care either. Anything further? Does she have another court hearing, Mr. Flanagan?
Yes, Your Honor. May 14th,
What is that for?
review.
So we're in April. Is it realistic that she's gonna pay the restitution by May 14th?
Yeah.
Is that her halfway point? Or that May 14th, is that her halfway point? Sorry, I'm asking you questions that I have to file right in front of Ms. Flanagan. No, that's her first review. I placed her on a 9-month probation just in January. That's not her. Oh, wait. January, February, March, April, May. That is her halfway point. I'm gonna keep the. How we get in April and the restitution here was originally scheduled for February. Oh, wow. February 20th. Was that the last date? No. We must have adjourned that, but I don't know why. Okay, none of that. I'm gonna keep the May 14th date. Am I available May 14th? Yes, I am. I can look at it and see. Yes. Okay. Okay, we're gonna keep the May 14th date for next. And if you have completed terms and conditions of your probation, then I will consider early discharge at that time. We are all set. Have a great day. Stay safe. You're welcome. I'm ready on right. Everyone turn on your cameras. Ms. Watson, turn on your camera, please. Clarissa Watson, please turn on your camera. Mr. Hayes, your witness is not going to be counted present if she does not turn on that camera. This is case number 260-444-9401, the people of the state of Michigan versus Hilda Wright. And who talked to your witness? Who did? Nobody?
Your Honor, I talked to her at length by phone, not on Zoom.
Well, then you didn't tell her to dress appropriately for court, Mr. Hill.
I did not see her attire. I know she had an appointment at the VA.
I don't care about an appointment at the VA. I really wish you would stop doing that. I really do.
What did I do?
I'm not talking to you or about you, Ms. Wright. Please stay muted until asked to unmute. Mr. Hill, I'm not going to allow your witness to appear in court in this matter. I will send her to the breakout room and you can get her appropriate for court. It's important to talk to your witnesses on Zoom. That's why we do what we do. And that's why it runs smoothly. Ms. Wright, I'll be back with you in a moment. Mr. Hill, please go to the room and speak with the witness. What happened to the interview? Mr. Hayes, I'm ready. Madam Interpreter, I'm ready. All right. Please unmute, Madam Interpreter.
State your name for me, please.
Sarah Asmar, Michigan Courts Arabic Interpreter.
Thank you. Can you raise your right hand, please? Do you swear or affirm that you will translate from English into Arabic anything I say, counsel says, or the clerk says, and from Arabic into English anything Mr. Isho says to the best of your ability?
Yes, I do, Your Honor.
And I apologize, and in accordance with the law.
Yes, I do.
All right, ask Mr. Isho to step up to the podium, to the mic.
سيد إيشو اتقدم على الميكروفون.
This is case number 260-443-0301, the people versus Faraz Isho.
هذه هي القضية المرقمة 26-04-44-30-301 الشعب ضد السيد فراس إيشول.
Defendant is charged with one count.
المتهم
Gambling, disassociated person.
أنت متهم بالتهمة الأولى على الشخص.
Today is the date set for pre-trial conference.
اليوم هو التاريخ والوقت المحدد لجلسة اجتماع تمهيدية.
Appearances, please.
حضوركم رجاءً.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people.
أنا اسمي روبرت وأنا اللي أمثل الشعب أي الادعاء العام.
Good morning, Your Honor. Tanisha
Warford, you're gonna have to speed up. I'm trying to get my jury back out here. You take long pause. Come on, let's go.
Tanisha Warford appearing on behalf of Faraz Isho.
أنا المحامية اللي أمثل المتهم فراس إيشو. Okay.
Ms. Warford. All right, Mr. Isho, state your name for the court.
سيد إيشول اذكر اسمك وقول لنا شلون تكتبه للمحكمة.
هو فراس إيشو F-I.
No.
فراس إيشول.
Thank you. Today is the date set for pre-trial. Ms. Warford.
Your Honor, we continue to plea of not guilty. Request that this matter be set for a final pre-trial conference and request discovery.
إذن في الوقت الحاضر احنا نطلب أنه يتقدم موكلي أنه غير مذنب ونطلب وقت آخر من أجل التحريات.
The court continues a not guilty plea on behalf of Mr. Isho, sets the matter for final pre-trial conference May 8th.
إذن المحكمة راح تدخل إقرار بعدم الذنب بالنيابة عن السيد فراس إيشول، وفي المرة القادمة راح تنعقد جلسة اجتماع نهائية وتمهيدية في تاريخ شهر الخامس اليوم الثامن.
At 9:00 a.m., discovery should be submitted by April the 24th.
إذن الجلسة الاجتماع القادمة راح تكون الساعة 9 صباحا شهر 5 اليوم 8. كل التحريات لازم تقدم إلى المحكمة بمدة أقصاها 24/4. Okay.
Anything further on behalf of the people?
أي شيء تحبون تضيفون أيها الادعاء العام؟
No, Your Honor. Thank you.
كلا حضرة القاضي أشكرك.
On behalf of the defense.
ومن الدفاع لا شيء إضافي من طرفنا.
No, Your Honor. Thank you.
All right.
شكرا حضرة القاضي.
I'm sorry, Madam Interpreter. I do apologize for talking.
It's okay.
We're all set.
إذا رفعت الجلسة.
Until May 8th at 9:00.
أشوفكم في تاريخ شهر 5 اليوم الثامن الساعة 9 صباحا.
Have a great day. Stay safe.
أتمنى لكم الموفقية وكونوا سالمين. Thank you, Judge.
All right. Thank you. Thank you for coming back so late. I appreciate you.
Of course.
All right. Thank you, Mr. Hayes.
Thank you, Your Honor. I think that's everything. I hope that's everything.
I think so, yeah.
All right.
I highlighted, I only have 2 highlights for you, so that should be it.
Have a great
All
day.
right. All right, you also. I'm ready on Shelby and then I'm ready on Wright. Miss Shelby, start your camera.
Your Honor.
Oh, the complaining witness was in person. Are they still here?
I
On
think so.
Shelby. I don't know the name.
Ms. Whitman.
All right, I think we're gonna go till 1 o'clock. Does anybody object to that? All right. Well, yeah, I don't like the people being in person and the people not in person, but nonetheless. All right, she can stand right there, just right there. All right, this is case number 25046466901, the people versus Shakira Darness Shelby. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
Good morning, Your Honor. Alex Hill on behalf of the people. Also present is our complainant. Ms. Whitley, nice and loud, will you tell the court your name?
Cheryl Whitley.
Thank you, ma'am.
Good morning, Your Honor. Tanisha Warford appearing on behalf of Shakira Shelby, who is present via Zoom. Ms. Shelby, please state your full name for the record.
Shakira Darnese Shelby.
Today is the day set for final pretrial. Ms. Warford, how are we proceeding?
Your Honor, we are requesting a date for jury trial at this time.
Court continues the not guilty plea. On behalf of Ms. Shelby, sets the matter for jury trial May 14th. At 9:30 a.m. with a final pretrial conference May 8th at 9:10 a.m. Ms. Whitley, you have appeared today, and of course, your appearance is not required on May 8th. However, if you want to come May 8th, you can come. That is the day that we will determine whether or not the case will in fact go to trial on May 14th. If you don't appear, the prosecutor's office will let you know whether that May 14th date is a go, okay? Anything further on behalf of the people?
Thank you, Ms. Whitley. Nothing further.
On behalf of the defense?
Nothing further today, Your Honor. Thank you.
We're all set. Have a great day. Stay safe. I'm ready on Benton. Do I have anybody else in person?
Yes.
Who?
Ms. Stevenson and Robert.
Stevenson?
10:02.
Yeah, 10:02.
Oh. I cracked myself up. Oh, and you told me that earlier. Bring Stevenson in. It's highlighted.
Crowder 2 or no?
Who?
Crowder. Just Crowder. Don't know.
Oh, he got it on there. Yeah, sure. I need to see that I have some in person. All right, I forgot I was supposed to go to Wright next. Okay, let me bring in Wright. Bring in Wright. I'm ready on Benton. This is case number 250-450-5601, the people versus Kenneth Roger Benton. Defendant is charged with 1 count of operating while visibly impaired. Today is the day set for review. Ms. Moore, for your appearance, please. The gentleman on the back row is not appropriately dressed for court.
Mr. Warford appearing on behalf of Kenneth Benton, who is present via Zoom. Mr. Benton, please unmute and state your full name for the record.
My name is Kenneth Benton.
Today is the day set for review, and based on your notes, Here's that Mr. Benton might be ready for discharge, however, I apparently didn't bring my folders, so give me 1 second to pull up the review. Where's my Outlook? Where's my Outlook? Oh, there it is. Why is it not opening? Right. Do you agree with, that's what you believe, Ms. Warford?
Yes, Your Honor, we do believe that Mr. Benton has satisfactorily completed all the terms. We would be requesting a discharge from probation today.
Today's day set for the review, and yes, Ms. Boyd, according to probation, he has completed the terms and conditions of his probation, including submitting to your analysis. I don't even know what this means. This is not the truth. Help me. What is she talking about right here in the notes? Did this come to you? Can you pull this up, Mr. Flanagan, please, Benton? She says the defendant submitted to 1 urinalysis as ordered. That is not the truth. Can you?
I think she, I don't know if this is what she means, but at November 13th.
Once per month.
Yes.
Can you ask her what she means by this? So it appears that he has completed the terms and conditions of his probation. However, I'm hopeful that Ms. Boyd has made an error in her report that he submitted to 1 urinalysis versus once a month urinalysis. I most certainly did not order 1 urinalysis test on a drunk driving case. I most certainly did not. My order is clear, once a month urinalysis. Once a month, once a month. She's not answering. Now, Mr. Benton, I'm gonna know the answer to this question in a couple of minutes. So I'm gonna just ask you. Were you submitting to your analysis once a month, or did you do 1 urinalysis test?
No, ma'am. I started off 3 times a month, then in November.
Don't go back to 3 times a month. I'm talking about since November. I reduced you to once a month. Did you take the test in November?
Every month, once a month, ma'am. Yes, I did.
Okay, well, let's confirm. I'll bring you back out as soon as Ms. Boyd answers her phone. All right, I'm ready on right. This is recalling case number 260-444-9401, the People versus Hilda Wright. Defendant is charged with 1 count of brandishing a weapon. Today is the day set for pretrial appearances, please.
Good morning, Your Honor. Alex Hill on behalf of the people. Also present is our complainant, Ms. Watson. I'm going to send you a prompt to mute your microphone so you can state your name for the court, please. Please, yeah, unmute. I'm going to send you another prompt. Thank you. Say your name, ma'am.
Clarissa Elizabeth Watson.
Thank you.
Good morning, Your Honor. Tanisha Ward Ford appearing on behalf of Hilda Wright, who is present via Zoom. Ms. Wright, please unmute and state your full name for the record.
My name.
Uh-oh, sorry. Try it again, ma'am. I don't know who.
Hilda E. Wright.
But you might have to go back in my office and do what you did before.
Okay.
All right, how are we proceeding, Ms. Warford?
Your Honor, we will continue with plea of not guilty. Request that this matter be set for a final pretrial conference and request discovery.
The court continues a not guilty plea sets the matter for final pretrial conference, May 8, 2026 at 9:00 a.m. Discovery should be submitted to defense by April 24th. Bond will continue with no contact with the complaining witness. Ms. Watson, you have appeared today and therefore you are not required to appear on May 8th. However, you may appear if you want to. As a complaining witness, you may appear at all scheduled court appearances. Anything further on behalf of the people?
Your Honor, I did want to place on the record that Ms. Watson has made me aware that she is alleging a violation of the no contact order yesterday. These women live in the same apartment building, and Ms. Watson advised that Ms. Wright attempted back when she was in the elevator, and she's very concerned. Now, I understand we need to submit documentation.
Y'all gonna stop this right here. We're not gonna speak. We're not gonna respond. We're gonna listen. Continue, Mr. Hill.
So I am working with Ms. Watson. I don't know if a police report was filed, but any documentation I will submit to the court as well as defense and request a bond violation hearing at the court's earliest opportunity. We wanted to emphasize or ask the court to emphasize the importance of no contact despite living in the same building.
Ms. Warford, were you made aware of the allegation?
Your Honor, no, I was not made aware of that allegation. My client has informed me that she does live in the same building and that she specifically does not get in the same elevator as Ms. Watson. So I was not aware.
Ms. Watson, if you do that again, I promise you it's not gonna turn out good for you.
I'm sorry, Your Honor.
You're apologizing. Let's just act right on the front end, so we can stop apologizing on the back end. Now, everybody in here is an adult. I do not handle juvenile matters. So everybody is going to act like adults. And if you don't know how to come to court on Zoom, come in person. Come in person. So number one, Mr. Hill, you should have notified Ms. Warford of the allegation before we got on the record. Number two, if the people want to request a bond violation hearing, then the court will receive the request at the appropriate time. Number three, it's hard for me to believe it's not true when people come on here acting the way they act. It's easy for me to believe that it could happen. When you on here rolling your eyes, talking about my God, let's keep going because I'm gonna put it all on the record. Rolling our eyes, talking about my God, waving our hands, looking up in the ceiling,
I'm just saying, Your Honor, I just got
I don't care. The fact that you are interrupting me right now.
Yes, ma'am. Yes, ma'am.
When we don't know how to come to court on Zoom, we come in person.
Yes, ma'am.
I am not going to be a babysitter. I am not going to babysit people who live in the same building. I'm not going to do that. I'm not going to micromanage a no contact provision. I don't need any help. I don't need any assistance. I don't need an amen corner. I don't need an up and down head shake. I don't need a left to right head shake. What I need is for people to sit up straight, ready to attend court. Ms. Wright, I'm talking to you right now.
I'm sitting upright.
Yeah, you just sat upright and you just stopped shaking your head. And there's no need to engage me in conversation. There's no need to engage me in conversation. If the people have sufficient proof with respect to the violation, then I will receive the request for a violation hearing. Please know that I am not a respecter of person. Whoever is violating my no contact order, I have no problem addressing it to that person, the defendant or the complainant, whoever it may be. Is there anything else on behalf of the people?
Nothing for the record today. Thank you, Your Honor.
Behalf of the defense. On behalf of the defense?
No, Your Honor, thank you.
We're all set. Everyone have a great day. Stay safe.
Thank you.
There are so many things that need to be said about that last case. And quite frankly, probably none of them are appropriate. So I'm just going to stand pat and say that I agree with Judge Bryant on 90% of everything he said right there about having court decorum, ladies and gentlemen. If you can't join court on Zoom and behave as if you're in court in person, then don't join court on Zoom. Go in person. Very important lesson that we all need to learn. Thank you very much for hanging out with me, ladies and gentlemen. It's been a long, crazy day. If you joined Colin earlier, you know it's been one of the craziest, because he had a bunch of crazy cases. I had a bunch of crazy cases. Mike had a bunch of crazy cases. We've all been watching crazy cases all day long, and it's over now. It's over. But there will be more cases tomorrow, and your local foosball will be back at 8 p.m. Central Time, 9 p.m. Eastern Time. I'll have more cases right here, same wolf time, same wolf channel, just like always. For now, I want to say thank you, everybody. Thank you so very much for all of the well wishes, all of the chats, all of the donations. Wendy Creek, thank you so much for your super chat. Thank you, everybody. Thank you, all the lurkers. Thank you, all the chatters. Julie, Mama, Cat, BM Cougar, oh boy. Let go of the rope. Not worth it. Steven, not worth it. Marty, thank you for showing up again. Word. Fat Boy is back, and I'm happy. Ladies and gentlemen, Rhonda's the weather queen. Be weather aware. I am your lone wolf Oosel. I'm your humble curator and your host for these here videos, and I am out. And for your final moment of wisdom in honor of Ferris Bueller's Day Off, before we say, get out of here, there's nothing else to watch, remember, always forgive your enemies. Nothing quite annoys them so much